So thank you all for coming. I'm Bob Lawless. I'm the co-director of the program on law, behavior, and social science. And we're here today to celebrate the publication of The Psychology of Tort Law, written by our own Jennifer Robinault, the Alice Curtis Campbell Professor of Law, and Valerie Hans, Professor of Law at Cornell University, and currently the President of the Law and Society Association. When you think about how to celebrate a book as academics, the highest compliment we can pay to a work is to engage with it analytically and critically, and so that's what we're here today to do. We've put together a great panel of commentators to discuss the book. The plan is for them to comment on the book and then give Professors Robinault and Hans a chance to respond, and then we're deliberately leaving a lot of time for Q&A to have a discussion about the book and about what you all think, and then adjourn for box lunches in the pavilion. My main role here is to stay out of the way. That's why they put me on the end. So let me introduce the panelists. Stephen Daniels is a senior research professor at the American Bar Foundation. He is a leading figure in the study of the American civil justice system and has written extensively on trial courts, juries, plaintiffs' lawyers, and the politics of the civil justice reform. He's written on medical malpractice, products liability, and punitive damages. Barney Schultz is vice president and counsel at State Farm Insurance, where he heads the litigation division of the corporate law department and oversees its litigation information management and technology, litigation support, and human resources in agency sections. Mr. Schultz joined State Farm after 34 years of private practice and joins me in two things. First of all, being a resident of Peoria, Illinois, or native of Peoria, Illinois, I should say, and also as an alum of the College of Law. We are also scheduled to have Rebecca Sandifer from our Department of Sociology on the panel, but she was called away for a family emergency. She wrote, "I'm sorry to miss the event, and I was looking forward to it very much. It is a great book that both answers and raises all kinds of fascinating and important questions." So with that, by way of introduction, I'll turn it over to Steve.
Thank you. Thank you, Bob, for inviting me down to Champaign to talk about what really is quite a wonderful book. And I'm going to structure my comments roughly around what Bob had suggested. Given some time limits, one could talk the entire hour on what's in this book. First he says, what will be the takeaway for my discipline on what's in this book, of looking at how the research in psychology speaks to tort law. And the book really digs in deep in terms of different principles and concepts in tort law, the way the system operates, and what psychology and the research literature can tell us about how well grounded different tort principles are, different processes are, and the like. I must say there's things in here I didn't even know about, both in terms of tort law and in terms of the literature. It's just a wonderful review of the empirical literature related to tort law. But Bob said first, well, what's a takeaway for my own discipline from this book? My training is in political science. I'm not a lawyer. And basically the takeaway for political scientists, is there anybody who's a political scientist in here? And it doesn't count. I know. There's a long history where Anna was at the Bar Foundation in a previous life. The takeaway for political science is, you guys got it all wrong, you missed the boat. Political science wouldn't look at anything that's in here. Would not look at the tort system, that's private law, civil justice. In political science, we don't do that. We study the Supreme Court, we study public law. Somehow the state's not involved with tort law and courts, but we ignore it. And besides, it's looking at things from the bottom up, not from the top down. So in a sense, the main takeaway is to political science, you guys are missing the boat. The response from political science would be, we don't care. Political science just does not look at this type of material, and there's a lot to be gained for my discipline in looking at the operation of something like tort law and what empirical research here in psychology can say that helps us understand what's going on where the problems might be, and how we might deal with them and how we might explain them. So again, my discipline, I wind up as one of a handful of political scientists who actually study civil justice, and so we're kind of seen as fringy characters, and we gravitate to law and society instead, which is an interdisciplinary group, which is pretty much made up with fringy people from every social and behavioral science discipline, and you see heads going up and down who know, and the folks over here. And this is meat and potatoes for law and society. This is what law and society really is about, of taking social science, behavioral science, its research, and its insights in helping us understand what we call law in action, not just law on the books. And that's what this really is about in a wonderfully detailed fashion. I must say, this is, before I forget, this is one book where you really need to read the appendix first. There's a wonderful appendix that takes all of the different psych concepts and stuff and tells you in a short snippet what they're about, and then where in the book you can find the discussion of different heuristics, hindsight bias, or schemas and different things that are talked about. And those things float around a lot in the literature, and you want to get a handle on them. That is probably the best reference point I've ever seen on how, to understand what psychology has to say about torts, and the wonderful examples that go with it. So really, you should almost start with the appendix and then work from there. Bob says then, after looking at what this does or doesn't say for one's discipline, what should be done? The more practical side of looking at what kind of changes can be made in the system, in the process, the way it works. And the book has any number of ideas of how to improve things, of where psychology and tort law merge or don't merge. And you can see things that the process can do, things that lawyers can do in handling cases, even practical things. What's a better warning on a label in terms of what the psychology literature might tell us, and the like. But the one thing that I thought about, and like most people, we always think about these things in terms of our own work, and stuff I'm working on now, and it's something not really addressed in the book itself. What does this mean for legal education? Got a room chock full of law students. And there are any number of implications for how we train lawyers in this book, in part because it is so neatly tied to the types of things you would see in a first-year class on torts. The real basic nitty-gritty stuff that usually you only get with in cases, the casebook approach. Here you get a completely different take on what's going on in this really basic area in the civil justice system. And so, really kind of interested in my own mind of what might this tell us about the way in which we train lawyers. Now, not everyone is going to be handling tort cases, but what you find is in looking at the types of concepts and research from psychology that are talked about in the book, they go beyond just torts. You start seeing the implications of what it means for other areas of litigation, for other areas of practice that may not be based on litigation, and the like. And it would really, if you think about it, it would change perhaps the way in which we would train lawyers by having them much more versed in the psychology, in this case, of what's going on, of why people bring claims or why they don't. And as they point out in the book, the vast majority of possible claims could become lawsuits never happen. What happens when people do bring a claim? What do lawyers do? What do jurors do? What do judges do? Fact finders, decision makers. Things that you don't get in a regular case book, but if you're really going to practice in this area, you really ought to know about. Now, one of the things I study are plaintiffs' lawyers, the people who handle these kinds of cases. And there's a lot of stuff that resonates here in the psych literature from what I learned from studying plaintiffs' lawyers. And so, but a lot of what they've learned as they go, on the seat of the pants, so to speak, based on their own experiences. But you could see how you could kind of jumpstart that by incorporating some of the things that we learn from psychology into a curriculum about torts, an advanced torts class, maybe not a first-year class, a trial practice class, that may get you beyond torts and the like. So it really grounds things in the everyday activity of doing this stuff, looking at what different actors do, what different decision makers do, and the like. So it really does make me think about the implications for the way in which we train lawyers in a much more interdisciplinary way that shows how other disciplines help us understand better what happens in the system and how we might go about doing things once we start practicing law. And then finally, Bob said there's the usual kind of academics thing. Well, what's it say about future research? And of course, you know, you've got 4 or 5 pages of things. They mention a lot in the book of areas that the psych literature has not yet gotten at or gotten at in much detail. The bulk of the literature really is about what they call fact finders or decision makers, primarily juries. But of course, if you know anything about the way the tort system works, most things don't go to a jury. Most things don't go to a trial at all. If anything happens, if there's a claim made, it's settled short of an actual trial. And in fact, juries are the least likely way in which a tort matter is likely to be resolved. Most things, if they go to trial, don't today go to a jury and never did. I'm always amazed in the literature now where so many people are concerned about the vanishing jury and the like. It's referenced in the book. What do you mean vanishing? It never happened. Juries were always the least likely way to resolve a case. But most of the literature and the research focuses on juries because of their great symbolic importance, I think, in our system. And they do help set the going rates for what may be the parameters for settling the vast majority of cases. But what that tells us is that we also need more insights from psychology on not just juries, but other actors. What about judges? Most tort cases, if they go to a trial, it's a bench trial. It's not a jury. What do we know about how some of these same tenets from psychology help us understand what judges do, or help them understand what they do in terms of the biases that we all bring to any decision-making context? The lawyers who handle these cases, there's a little bit we know about why lawyers, plaintiffs' lawyers, for instance, may take a case. Most plaintiffs' lawyers, despite what you might think from the TV ads, don't advertise, don't take every case. They tend to be pretty picky because, as one of them told us in an interview, if I lose, I eat the cost. You know, so there's real economic incentives there, but there are other things that go into a decision as to why a lawyer might take a case or might not, beyond the dollars and cents. And some of these same ideas from psychology I can think of coming up in interviews I had with plaintiffs' lawyers in Texas and the like, is they balance out what's a good case, why not, what biases they bring with them, what biases they see in the local legal culture, whether in terms of race, in terms of gender, in terms of taking a case, and then how they handle something after that. You know, what's this person like? There are certain kinds of clients you discover that become toxic. They won't take them no matter how good their case is. And then finally, the one other area where I always have some curiosity with this material, is it time-bound? Is it simply about today, the recent past, or will we find these same dynamics in the past? Now, I come from someone who studies the politics of tort reform, where there has been for more than 2 generations a real active effort to change the way or influence the way people think about civil justice, about torts, about people bringing lawsuits, particularly for money damages, and the lawyers who handle them. The American Tort Reform Association, which does a lot of work in this arena, lobbying and other things, but has as one of its tenets, they don't just want to change the law, they want to change the way people think about torts, about personal injury cases, the people who bring them, the lawyers who handle them, and tell people what they should do if they ever serve on a jury. And this has been a sophisticated campaign over many years. Does this mean we're seeing now the results of that campaign? Is that campaign kind of beside the point? It really doesn't influence what people do or how they think? A big issue, I think, is how much of this is time-bound how much of it is more deeply ingrained in the way in which we look at things. Psychology tends to not be something that thinks about change and variation over time, but wants to get at deeper kinds of ideas and attitudes. But will that hold up if we were to look at some of these same things over time? And again, you know, as most, I tend to look at these things through the lens of my own work. And there are lots of other questions that pop up for future research, and Jen and Valerie, you know, have a whole list of them in different parts of the book. So this is also kind of a godsend for people who do research. It's like, where do I go next? Oh, I'll look in here. I can find 6 or 7 things. Thank you.
Thanks very much, Steve. So, Barney?
I guess from the academic sort of to the practical. So first of all, thank you very much for the invitation to join you, and congratulations to both of you. I think it's a great honor to be invited to be the authors of the first edition or the first volume of this series. So that's a great testament to you and to your scholarship. So congratulations. I want to make clear at the outset that while I work for State Farm, and very happily, my comments here today are those of my own, and they're largely the product of 34 years of practicing law, as Bob said, as well as the last 3.5 years of practicing with State Farm. So my experience has been in the civil litigation almost exclusively my entire career, and that's the perspective that I read this book. And I give you great credit. I think it's incredibly ambitious to tackle the subject of psychology and tort law and try to do it in a manner that appeals to the legal education community, to frame this around sort of the traditional coursework elements of a tort classroom. I think it's challenging to try to condense so much empirical research as you have done into a readable form, and most important to me, to contribute or add to the body of readily available information on how psychology affects the law. Your editor noted at the beginning in the preface, I believe, that psychology has largely been at the periphery of the law, with 3 exceptions. And I think she pointed out that that tends to be in the area of eyewitness testimony and false confessions and jury consulting. And in the jury consulting area, that's where I really have the most experience. And I will tell you that it's been nearly 38 years since I graduated from law school here, and it's been fun to see the transformation in the practice of law to really embrace what psychologists have brought to the field of decision-making. Let me speak to that broadly, just decision-making. Largely, it's in the area of jury consulting and trying to fashion and frame your arguments. But I've really been able to see that, the jury consultants at first were treated with scorn because they weren't lawyers, and as time has passed, they're embraced warmly. And the recognition that virtually all of the jury consultants that I've dealt with in my career have doctorates in psychology. So these are well-schooled, hardened people who are disciplined and understand what it is they're talking about. And so from that perspective, I think the timing of your book is superb, because, at least to my observation, the acceptance of jury consultants and the value they bring is now accepted. And so let's turn the page and see where the role of psychology can offer additional insights to the practice of law or to legal scholarship. So I'm a believer. I was an outlier at the beginning of my career, that how dare you, you're not a real trial lawyer if you can't go by your gut instincts. You're not a real trial lawyer if you have to rely on somebody who's not a lawyer to help you try your case. And the truth of the matter is, I think that those people who are regarded as being especially successful or especially persuasive really had these elements innately in their ability as trial lawyers, whether it was to frame the argument, to tell the story, to understand human behavior. Those people who were most successful were the ones who innately had those skills. We don't all have them, but there's nothing that says you shouldn't draw upon other disciplines to learn from that and to gain that advantage. So that's sort of where I would start off with my comments. I think that as I read the book, and again, of course, I can confess that I read it from the perspective of having practiced law and been in civil litigation most of my career, what struck me was how often you had referred to the story model of decision-making. It's in your first chapter. It carries through in your sections on negligence. It carries through on your sections of causation. It carries through, I think, to some extent in your discussion of damages. And one thing I was curious about is that I think that you characterized, well, your characterization, I think, if I'll get it correctly, is that the story model theorizes, and I probably disagree with the theory because I actually think it's proven, but the story model theorizes that fact finders construct narratives or stories from an array of information or facts that they've heard during the trial in order to arrive at decisions. Or another way to look at it is that the stories or narratives that account for most of the evidence that seem consistent, plausible, and coherent are the more persuasive versions. And all of this is against the backdrop of who is your fact finder. And your fact finder may be the juror, it may be the judge. I would extend it that it may be your adversary in a negotiation. But all this, the idea of composing the story based on the facts, that's coherent, that's plausible, that accounts for most of the evidence, that tells a story, also has to be judged by the decision maker and weighed against that decision maker's own background as far as what seems plausible to him or her. And so the opportunity for lawyers here, I think, with your book is to really understand those core concepts of what goes into the background of the decision maker. You know, it's useful to have some understanding of what hindsight bias is. It's useful to have some understanding of what outcome bias is, or confirmation bias. Most of the jury consultants that you work with will tell you that you do the exercise not to get a prediction of how you're going to do, but it's to understand what the obstacles are in the way that you've told your story that are interfering with those people reaching the conclusion that you want them to reach. And so that's where this field of psychology, I think, is offering immense opportunity, not only for tort law in the jury consulting, but in areas of client counseling, and I would say even in the areas of just basic client relationships, and that is understanding your client, what makes him or her tick. This is understanding human behavior, and that's at the heart of what you've addressed, and addressed specifically in the context of tort law. So I found that fascinating. I think, you know, to understand that our brains naturally try to make sense out of chaos and to seek understanding. We sometimes lose sight of that. And especially I think if you're starting your career and you have a case to try, I would simply say pause long enough to compose the story. The story really is incredibly persuasive. And as long as it accounts in a faithful way to what the evidence is, I'm not talking about spinning a yarn, I'm talking about telling a story. As long as it faithfully adheres to what the evidence is or what you think the evidence will be, you will gain a great advantage. And this is a great resource. That one of the benefits of this publication as well as other publications is that this realm of psychology is no longer restricted to those people who can afford to hire a jury consultant, but it's widely out there in the literature. And so this book adds to that, and I would say it adds immensely in a great way. So if I can, I'd like to, though, at least pose one question for you that maybe we can answer or I guess get addressed. I've spent a fair amount of time talking about and admiring the storytelling model as far as persuasion. There's a lot in the popular literature today, popular legal literature, about the reptile theory of decision making and how appealing to anger and fear in the jurors or the decision maker and really appeals to that most primitive element of our mind, and that part of the mind is what we have in common with reptiles or lizards, and that's a stronger predictor of outcome, that it is a stronger emotion, it acts faster than the higher level functioning, logical functioning in the brain. So if we have time, I'd be fascinated to hear what you say about that and how you react to that. Let me spend just a minute or two, though, addressing one other piece, and that is the commentary about insurance. I am completely in agreement with you that the role of insurance really does dictate a lot of behavior in the tort world. And that goes from the decision, as Stephen talked about, whether to accept the case, and that is there economic value in this to the lawyer to pursue it? Is there economic value for the client to pursue it if there isn't any insurance available? I think it also dictates in trial strategy or litigation strategy. Granted, we don't try that many cases, but we have a lot of litigation on who you choose to sue or who you target in a multi-defendant case, how you shape the evidence or the presentation of the evidence. Even if somebody may be less culpable, are you able to make a plausible case of liability against the defendant that has more insurance? I think these are very, very important concepts, and we should never ignore them because it is the reality. And the final piece of that, I think, is also the recognition that in most instances, people don't pursue a defendant to collect the damages that have been awarded over and above what the available insurance is. So that's human nature, perhaps. We'll let you speak to that, but it is, in fact, a reality. So with that, I guess the only short pick I have with the book is the commentary that the financial interests of the insurance carrier may be contradictory. That is, the interest to save money may be contradictory to what the policyholder's interests are. And I would argue that I think there's a place to consider the fact that the law imposes bad faith liability on insurance carriers who put their interests ahead of the interests of their policyholders. And whether that's an economic incentive or a behavioral incentive, I'll leave that to the scholars in the room. But it is a tremendous disincentive for insurance carriers to put the interests of the carrier above the interests of their policyholders. Thank you.
Thank you. Yeah, this is one of the great things of being a moderator when you have people who are not self-timekeeping. So thank you both. So with that, we're going to let Valerie and Jen have a chance to respond. So Valerie, you want to start?
Yeah, I'll go first. And let me just thank you, Bob, for doing all the hard organizing work of this panel. It's already been completely fascinating to me, and I'm looking forward to getting a chance to respond to some of those comments, but also to Dean Amar, who's helping sponsor the panel. And I think you're absolutely right. It is, at least for us, just a tremendous honor to be able to have our book examined in this way. And we look forward to responding to those comments. But first, Jennifer and I wanted each to talk a little bit about what inspired us to write this book. I mean, why we took up Linda DeMain's offer to do something on the psychology of tort law. And for me, it dates back to the fall of 1986, where I was sitting in a law school classroom. I was on sabbatical. This was my experience at Stanford Law School, and I was listening to the first case of the year, which was a case called Vosburgh v. Putney. Anybody heard of it? Maybe some of the first-year law students. Most of you know that that was a famous Wisconsin case that often is the first case in a torts casebook. It was a lawsuit between two young boys, one of whom had kicked the other in the shin as their class was being called to order. The kicker was Putney, a guy from a wealthy family in the Wisconsin neighborhood, and Vosburgh was the victim, sort of a pitiful guy from this vantage point. When I read some of the background to this case, you almost got a sense that this was somebody who was picked on. We'd call it bullying today, I think. So Vosburgh v. Putney, what happened as a result of the kick, which was a purposeful kick, right? Putney intended to kick Vosburgh, was that he kicked him in the shin, and Vosburgh immediately began crying. And it turned out the site of the kick became inflamed and led to a very bad outcome on his part, including a disability, doctor's bills, medical bills that just about equaled his poor father's salary. And so Vosburgh sued Putney, and the Wisconsin jury, the kind-hearted, generous Wisconsin jury, found for the plaintiff Vosburgh and awarded him damages. And the case was appealed. And that appeal is what appears in the opening pages of many, many torts casebooks. The torts professor who's teaching this class, I think the law professors will know this guy, Robert Ellickson, who has a law and economics bent. He was then at Stanford Law, and he raised lots of interesting, to me, really interesting economic questions in our class discussion of this case. Like, okay, suppose you have an injury where somebody intended to engage in the action, but certainly didn't intend the consequences. Supposing that's a young boy who might be assumed to not understand the full consequences of an injury. So from an efficiency perspective, really, which party should bear the cost? And what if you have what might be called an eggshell plaintiff like Vosburgh, one for whom a tiny little kick would lead to really dramatic consequences? Should they bear all the responsibility, given that the rest of us can't necessarily foresee the consequences of this, of the injury and the extent of the injury? Is it better to spread the financial consequences of an injury like this more broadly? And one question that kind of merges the economic and the psychological: did the deep pockets of Putney and his family actually help drive the claiming of Vosburgh and his family? As we debated these and other economically oriented questions about this case, I was really struck by some of the psychological questions that were also at the heart. How do we decide what's an intentional action, and how do we attribute responsibility for intentional behavior? Does the context matter? Does the fact that this occurred in a classroom and that had been called to order matter? And what if the unexpected happens, as it did in this case? To what extent are we willing to hold a young person responsible? So you can see some of the psychological questions combined with some of the economic questions to make this a really fascinating case, one that I think helps to explain why it's such a great vehicle for beginning the study of torts. And I returned to it again when I taught torts at Cornell Law School, and Jennifer and I found a prominent place for it in our book on the psychology of tort law. So the classroom discussion of that case decades ago also confirmed for me a key insight that I think was really important in our decision, certainly my willingness to go along with this book, and Jennifer has her own. There were just so many central psychological questions that are embedded in tort cases, yet a lot of times in the discussions in the tort classroom, they were simply raised as speculative, interesting questions, and then we proceeded along. You know, we went along on to the next case, Garrett versus Daly. And part of it was, even though psychologists have been studying things like intentionality and things that would be covered typically in an intentional torts case, they didn't do it with an eye to addressing issues that might arise in a torts case. For that matter, issues that might arise in negligence cases or strict liability cases. It was as though the field of psychology would pick and choose an interesting tidbit from the real world of law and then go on its merry way, examining questions in the often sterile atmosphere of a psychological laboratory. So you had research that wasn't quite on point, and you also had, I think, a problem that a lot of psychological research wasn't brought to the attention of lawyers, except progressive and forward-thinking lawyers like Barney Schultz, who was already on it a couple of decades ago. But it struck us that there really was a place for a book that took the psychology from whatever source, more applied field studies, but also psychological experiments done in traditional laboratories, and really thought through how they could apply to some of the key issues in tort cases. And I think one of the things that really, for me, is the central purpose of our book was to link this world of psychology to the world of torts, and to perhaps encourage not only lawyers, but also other scholars to take up a kind of second generation of research that more effectively marries these two fields. The fact that both Jennifer and I teach in a law school, I think, is really central to how we organize the book. Both our commentators mentioned the way in which we organized it. The chapters are actually organized, they could be chapters in a torts casebook. You know, we start off with after introducing the style, the way in which the tort system functions and how claims are brought. We begin with a chapter on intentional torts, talk about damages, causation, negligence, and defenses in scope of liability. So using concepts that are familiar with people in the world of law. And I just don't think I could have written this book, let alone organized it in this particular way, if I wasn't teaching in a law school. If I was in a social science department, I think that would have been a real challenge, a major challenge. So I think you have to be, and Jennifer helped so much on this part, very intensely familiar with the legal rules and some of the nitty-gritty of torts and civil law and civil procedure more generally to be able to do the connection, at least the initial connection. So that's one of our goals, is to try to maximize the linkages between, oh, I get it, yeah, okay. We got to give Jennifer enough time. Our commentators were well disciplined. Now we come to the authors. Anyway, so we're really hoping that the linkages work really well. There's another thing that was mentioned also by both of our commentators that I really hope, and that is we'll be able to contribute to the still very lively tort reform debate, and by doing that, try to provide more information to people, the public, as well as people in the academy. So with that, I'll turn it over to Jennifer.
Okay, so that's a good,
Yes.
I'm loud. So thinking about the tort reform movement is a good place for me to start, because thinking about my first projects and the first draw to this topic for me was when I was thinking about trying to develop a better understanding of tort decision-making in the context of tort reform that was going on when I was in graduate school. In particular, tort reforms that were focused on things like punitive damages, which is still a big thing, but it was particularly big at the time. Caps on punitive damages were a popular reform at the time. A couple of states at the time had decided to take the punitive damage decision-making away from juries and give it to judges, because they thought there were differences between how juries and judges would approach that decision. But a lot of that reform effort was being done in a situation where there wasn't a lot of data being looked at about the tort system itself or about what the effects of the reforms would be. So in one study, for example, Christina Studebaker and I looked at the effects of caps on punitive damages and tried to figure out whether there could be potentially an anchoring effect of a cap such that it would be cutting off the very few awards that were really, really high, but that it might serve to pull up all of the awards that were lower than the cap, and it might have some sort of distorting effect on the mass of claims that tend to be relatively modest in size. And in other work, I looked at trying to compare the decision-making of juries and judges in terms of what kinds of factors influenced their punitive damages decision-making. And it was in that sort of realm that I was most interested in questions about tort law and tort policy and how that related to the things I was learning about in psychology. So questions about the purposes and effects of the various reforms that were being proposed. Questions about the purposes of punitive damages in the first place, and why we have them and how they're determined and what purposes they serve. Questions about the purposes of tort law and the purposes of claimants and defendants, and how those purposes were coinciding and not coinciding in terms of what the system needed to accomplish, but what individual participants needed to accomplish. How people think about negligence, how people think about causation, things that psychologists had studied, but not in a way that was connected to the law much at all. As I think Barney said, much of the law in psychology at the time focused on issues that related to mental health topics, civil commitment, insanity defense kinds of things, or to various facets of criminal law. Thinking about juries and eyewitnesses, and even those topics could have been more about the civil law. They tended to be focused on in criminal terms. What do we know about eyewitnesses in criminal cases? What do juries do in criminal cases? There were, however, a few pockets of work going on in psychology and tort law, and importantly, Valerie's work on civil juries was going on at the time. Valerie and I first met when she came to present some of her work on businesses as defendants in tort trials and litigation attitudes. And I think she was working on her book on business on trial at the time. And so that was going on. A pretty landmark article by Michael Sachs called "Do We Really Know Anything About the Behavior of the Tort System and Why Not?" came out at about that same time. And then there were other work by non-psychologists that were empirical in nature and about the tort system that was sort of percolating as well. So Steve Daniels' work with Joanne Martin about the politics of tort reform was going on at that time. Work by Ted Eisenberg on comparing trial by juries and trial by judges was going on. And it was that work on the civil justice system that I found the most fascinating. So as Valerie and I tried to sort of pull together these strands of research and work that has been done since then to think about what work in psychology was relevant to tort law, we tried in many ways to be fairly comprehensive, to be pretty broad in our thinking about how the psychology might be relevant, both in terms of coverage of the psychology and also in terms of sort of a range of tort doctrines to which it might apply. At the same time, though, there's just so much that we couldn't include and so much that still remains to be explored. And so part of our hope in doing the book that we did was to provide insight into the topics that we covered, but then also to sort of set the stage and draw attention to lots of other questions for scholars to tackle. Ideas for new research at this intersection, hopefully providing a roadmap for a lot of scholars going forward. And we do suggest a lot of areas that are sort of ripe for empirical research, but we've really only scratched the surface. Even in just the past few weeks and months, I've had colleagues in discussion with me raising questions that we didn't even, some of them we didn't even really think about including here that sort of go beyond. So I talked with Matt Finken the other day about the psychology underlying the concept of vicarious liability, right? There's probably a lot to mine there, not something that we talked about. Talked recently with a colleague at another school about questions about what a judgment of tort liability communicates to various audiences about the defendant and the defendant's conduct. Is it simply sort of a cost-benefit kind of decision, you've got to pay for the cost of the harm you cause, or is there some sort of moral judgment that's being made? And our sense was that different people think about that communicative aspect of torts in different ways, not something that we've really pursued here. And those are only two questions that have come up recently among many that can be. I see the paper coming down the aisle. So really, we sort of wanted to set the table for thinking about these kinds of questions. And the kinds of questions that highlight in some ways the work in which my colleagues here at Illinois and my students here at Illinois have planted the seeds of, have grappled with me in class. We've drawn on work by David Hyman, by Steve Daniels, other people in the room, and various of you helped us with comments on the book. Leslie Wexler and Tom Ulen and David Hyman all helped us out with providing us feedback about what we were doing. So thanks to all of you. Thanks to Bob for pulling this together. Thanks to you all for coming. And thanks to Valerie, because this has been fabulous partnership. And we were upstairs earlier this morning planning some next stages of things. I think we may do that some this afternoon as well. So it's been great to work with Valerie. I have to say that I'm pleased that you think you should read the appendix first, because we had it in the introduction to the book originally, and we were persuaded, I guess. We lost that battle to move it to an appendix, but it really structured our thinking about how to go about thinking about this intersection in a way that would be accessible to lawyers and both psychologists. So I'm being told I have to stop.
Yes.
And some of you know I don't listen to him very often.
This is true. This is true. So,
I will.
except the piece of paper said to wrap up for Q&A, to allow
Yeah.
Q&A, because we really didn't want to leave time. And I even said when they set up the room, we're not going to do a podium because we want to leave it more informal and signal Q&A. So Sally's, I think, we're going to pass around a microphone while we're doing that. I'm going to start off. I'd be interested in the answer to Barney's question about the
Reptilian
idea of the
brain.
right. Yeah, it appeals to me.
Frightens you.
Not surprising.
No, you don't know me well enough. Actually, not at all. No, but in all seriousness, so what about this idea that appeals to arguments of anger and fear are going to be more persuasive than, as I understood the question, to kind of more of a narrative storytelling schema?
Yeah, I think they have a point that anger can be a driver of decision making, but the idea that anger would drive decision making only in favor of plaintiffs is, I think, flat out wrong. The hotel driver who brought me over here this morning asked me, well, what are you doing? I said, oh, I've just finished a book with the wonderful Jennifer Robidalt, and it's, he says, oh, what it's on? He says, Psychology of Tort Law. I responded, and he said, oh, is that, I put his words down, what's that? Where everybody's suing everyone all the time, you mean? Yeah, and by the way, we all pay for that. That was his commentary to me this morning, and I did want to say, hey, could you read our book? But it did, I think, capture what has been a very successful campaign on the part of business and insurance to convey the costs of tort cases. It's not just free money. It's not simply the deep pockets of particular agents, but actually those costs are passed along to consumers. So I think very effective. So both of you mentioned something about tort reform, and let me get a chance to respond to Steve here about, is this just right now, or has it been going on a long time? I think the campaign was really successful because it resonated with very deeply held values of individual responsibility and anger and fear about the loosening of and broadening collective responsibility. We do live in a very different world where large businesses are able to have very substantial impact on a very large number of people. And so it's appropriate to treat those actors somewhat differently than others. And yet it does move us away from our traditional adherence to a notion that everyone should be responsible for his or her own self. So I think it's a kind of moment in which some norms are changing, and it does scare people, and that helps drive decisions. But I think decisions that move people in favor of defendants as opposed to plaintiffs. Do you want to add anything?
The thing I will add that goes both to both of those points is that I think there are a variety of structures that are, inherent or ingrained, like our reaction to fear, even like things like the hindsight bias, that are sort of, I'll say, timeless, that are going to sort of persist over time, and they set up conditions for influence to change things over time, right? So I think there's something to the notion of that, sort of those basic primal reactions. To the extent that you can weave those into your stories, it's probably going to have some impact. And then at the same time, those are the kinds of reactions that make attempts at influence, whether it's attempts at influencing fact finders or attempts at influencing public opinion about the system, have some resonance. Yeah.
Thank you. So, questions? See, this is the first time the law faculty has been silent.
I got it. We're good.
Didn't take long.
So I only got to read a couple of chapters. So I'm wondering if you could tell us a little bit about what findings from psychology studies would be the most counterintuitive in terms of the tort system? So what would people be most surprised to learn about the tort system that they wouldn't know without sort of using psychology studies to figure it out?
That's a good question. So we'll probably, as we think, we'll come up with some examples. I think one doesn't come directly from the psychology. One comes from a broad range of social science on claiming. So I think most people would be surprised to know how low the claiming rates are. That's not directly about the psychology. It touches on it because thinking then about why do people claim and not claim and why are those rates so low is really interesting from a psychological perspective. So that's one. Another one that I think is very counterintuitive for a lot of people, and maybe particularly lawyers, is the research on procedural justice, which is the notion that people care a lot about how they are treated. And they care about things like having a neutral decision maker, and they care about having to be able to tell their own story, having voice in the process. And in some instances, they care as much or more about that than they care about the substantive outcome. That's not to say they don't care about the substantive outcome, but they care about process and being treated fairly a lot. And often, we get caught up in thinking it's all about the financial outcome, when process and other non-financial things matter a lot to people. Those are the two that come to mind.
Yeah, I think another thing is that this pertains to one of Steve's comments about wanting to study beyond just the public opinion and juries to look at lawyers, lawyer decision-making, judicial decision-making. From some of Jen's other work, we know that some of the same psychological phenomena, like hindsight bias, confirmation bias, motivated reasoning, they influence juries and jury decision-making, but they also influence judges, they also influence lawyers. And I really would like to reinforce Steve's exhortation to move beyond and really look at some of these other actors that are so key in the legal system of torts. And here I'll point particularly to Barney Schultz, because I think you are so right that insurance drives everything. Well, we say this too, in the book, but I think you put it very eloquently. It really is a major driver, and we don't know enough about it. And we should learn more about it. And I think we'd love to do some of the same studies that we report in our book with insurance adjusters, with people who are making decisions on the line. How much should we offer a particular person for an injury of this particular severity under particular context? So I think that's one of the things that I think maybe our next book will be doing. And I'll just say one final thing to Leslie, and that is, I think one of the lessons is that empirical work is often really valuable, because sometimes you really can't predict how particular phenomena are going to work out. And maybe the work on warnings gives a good example. You'd think, oh, gee, it would be a really good idea if somebody is going to be warned about what to do with this bottle, we put on the side of the bottle all the possible things that could go wrong, but research shows, no, actually, there's a limit to what people are going to be taking in. You've got to really evaluate what are the most important warnings, and the way in which they are presented, and how you force people to attend to ones that are really either life-threatening or could cause serious injury is an empirical question. It's not more is better, it's how you present it is better. So that we got, I think, not from psychology necessarily, but from taking an empirical approach to understanding things relevant to torts.
I was just going to briefly take a couple of comments that you said about the process and the importance of that, and whether it's counterintuitive or not. I think maybe it's overlooked, and that is, I think far too often people look at in litigation, they look at their lawsuits, or they look at their trials in terms of, is the jury going to identify more with the plaintiff? Is the jury going to identify more with the defendant? Or if you're a lawyer, do they like me, or do they like the other person better? And at least what I've been told anecdotally out of the jury research, and perhaps it's published, the truth is the jurors identify with the judge. And so that's an element that I would say is probably overlooked far too often as you're weighing the strengths and weaknesses of your case, and that is the jurors really think of themselves in terms of what the judge is, and that goes to how they're being treated, whether that's a waste of their time that they have to sit, how respectful or disrespectful are the lawyers to the judge.
Let me maybe ask one question here. I'd be interested, especially in Barney's take on this. As I look around the room, we have a lot of law students in the room, and thinking about getting this sort of knowledge into the law school classroom. And we have to teach torts, we have to teach civil procedure, remedies, bankruptcy, international bankruptcy, bankruptcy procedure. And guess what I teach? Right? But you get the point, right? We have a lot of doctrine. There's a lot of important things that we have to be teaching our students. And how can we or should we be fitting this sort of learning into the law school curriculum?
Well, it's not a complete answer, but Bob and I were talking. Our fathers are both lawyers as well, and both general practitioners, and so fundamentally the practice of law is dealing with human beings, and it's understanding human nature, and our understandings of human nature are built largely off of what our own experiences have been. And while at least I used to think that in terms of because I was defending lawsuits, that maybe if I chose a juror who had recently been unemployed, that was probably a bad juror for me because there was a wage loss claim that's going to be a part of this case. And what I've learned through the years really is the near-term consequences or the near-term experiences that people have are really of little importance. What is of greatest importance is what their background and their own development and their own experience has been over the course of time. And so I would say the takeaway from this is you can't overlook human nature, and you can't miss the opportunity to try to better understand human nature, because it carries through in everything that you're going to do as a lawyer, whether you're in litigation, whether you're counseling, whether you're negotiating, whether you're in a legislative environment, whether you're in the academy. You're always dealing with people, and you're shortchanging yourself if you don't make the effort to better understand how human beings think and work.
Well, we're pretty much at the end of our hour. So, yeah, Valerie, please.
Yeah. Can I just end with a little ode to Jennifer Robinault, who has been, she protests, but she has been such a wonderful collaborator and a real intellectual leader in this effort and a driver of me, if nothing else. And has just been a phenomenal collaborator. And I know Bob Lawless knows this, collaborating with her himself, but I didn't want the panel to end without mentioning just what a tremendous contribution she is and what a tremendous scholar she is. So,
Well, and Valerie's being very modest because Valerie herself is a tremendous scholar, and thank you for coming all this way. And I'm sure, Jen, I see Jen nodding. I'm sure this book wouldn't have happened without your driving force part of being part of this as well. So. I was just going to conclude. I would say this is a fantastic book. It is exactly the sort of thing I think that law schools should be doing and being more involved in, and trying to bridge the social sciences and as well as legal doctrine. So this is a fantastic book. Thank you for writing it, Steve, Barney. Thank you for coming. We really, really appreciate it. So thank you, everyone. Thank you to the panelists. And so let's give them a round of applause.